Hello, Miss Appleby. Please take a seat. I believe you're here today on behalf of your father.
That's right. Dad's 76 now, and I don't want the stress of this situation making him more worried or ill than he already is. I was hoping to be able to do a fair bit to help him without him having to be too involved.
That's fine. If confidentiality becomes an issue, we can draw up a document later that gives you permission to disclose confidential information and so on. But we're fine for now. So, how can I help?
Well, basically, Dad's done an extremely silly thing. He has a very good friend from his army days called Bob Allen, and Bob's daughter Victoria got divorced last year and was left more or less homeless. Dad's known Victoria for all of her life. In fact, he's her godfather. When she got divorced, she came to Dad with a sob story about being left on the street, and he lent her some money towards buying a new house. If I'd known about it, I'd have stopped him, because I've never quite trusted her. But I didn't find out until it was too late. That was a year ago, and she hasn't repaid a penny. As far as I can see, she has no intention of repaying him at all.
Oh dear. This is a very familiar story, I'm afraid. It's always dangerous to lend money to friends and family. What's Victoria's full name?
She was Victoria Allen before she was married. Then she was Victoria Winter during her marriage, and she's Victoria Allen again now.
Do we have an address for her?
Yes, she moved away from the area just after Dad gave her the money without leaving a forwarding address, but I found her online. 10 Oakfield Gardens, Battersea, London. As far as I can tell from looking at Google Earth, she lives in a basement flat.
Thank you. And how much did your father lend her?
God, I'm afraid it was £65,750. Everything he had in the bank. Sorry, I'm getting upset. My dad's so nice, he would have given her everything she asked for.
That's an awful lot of money, and I quite understand your concern. Did they have anything about this agreement in writing, do you know?
Not a formal contract as such, just something written on a bit of paper where she agrees to pay him back at £300 a week. It's just a few words, really, but they've both signed it.
I see. So we have no idea if the monthly repayment contains interest, or even if there's an obligation on her part to pay interest at all. Can I ask, have you contacted the police about this? There may be an element of crime here based on what you've told me so far.
Oh yes, they said the bit of paper proved that this was a civil matter and told Dad to be more careful in future. They stressed him nearly as much as the loss of the money. To be honest, they were, if I can say so, worse than useless. I don't want to involve them again.
I understand. Well, the good news is that we have her full name and her address and at least some written evidence bearing her signature that she has this money. That would make it rather difficult for her to convince a court that the cash was a gift. I take it as well that we'd be able to produce a printed bank statement that shows a transfer of the amount from your father's account into hers?
Yes, the money was transferred on 3rd of June last year in a single lump sum.
Good. Now, let me explain the law regarding your father's situation. First of all, I recommend that I write to Mrs. Allen, and if we have no joy, we'll issue her with what's called a letter before action. This is part of the pre-action protocol and means that we must write to her and give her a reasonable chance of repaying the money before we sue her.
I see. And what if she doesn't answer? She stopped answering her phone months ago, and when I go and knock on a door, she just doesn't open it. I don't think you'll have much luck.
No, I don't expect so either, but we'll have complied with the proper legal process, which is the main thing at this point. We'll give her 14 days to respond, which the court will regard as reasonable.
Then what?
Then we issue our claim. Any claimant has a period of 6 years from the date of the breach in order to make a claim, but this doesn't present us with any difficulty as the breach happened just a year ago. In fact, it dates from the day she didn't pay the first agreed sum of £300.
OK. And how about the problem that we don't have a proper written contract? Just a bit of paper?
Well, the law doesn't demand that a contract of this type takes any particular written form. In fact, it could be a completely oral contract, and the court would still regard it as binding. But we do have her signature. That's very much in our favour.
But what about the fact that it doesn't include information about interest or anything like that?
Then the judge, in the absence of any written evidence, must decide by means of a legal doctrine called the balance of probabilities who he or she believes. Both parties will give oral testimony under cross-examination from counsel. If Mrs. Allen isn't truthful, a skilled barrister will make her untruthfulness very evident.
This sounds like it'll be very hard for my dad. Presumably, her barrister will be allowed to question him. That'll be awful. And what if the court tells her she has to repay the money and she hasn't got any? It would be just like her to plead poverty.
She may well, but the court has various options for enforcement of an order. She is unlikely to have goods in her house that would add up to such a high value, so sending in the bailiffs probably isn't the solution here. However, the mere threat of them often works as a tactic to persuade people to pay up.
But what about the flat in Battersea? Can we take that off her?
In theory, yes. We could apply for what's called a charging order as a first step, which would secure the judgment debt. Once your father has that, he could apply for the house to be sold.
Good, that's what she deserves.
Let me write to her first and see what response we get. It would be helpful to speak to you again in about a week's time, and we'll take it from there.